Our next applicant is Mr. Samuel Langholz. Good afternoon.
Good afternoon.
And we'll let you begin your comments as you're ready.
Thank you, Chair Valentine, commissioners. I come before you today with a heart of gratitude, and that's where I'd like to start. First of all, thanks to all of you for serving on this commission. It's, as you know, a commitment of time and energy to review our applications and meet with us as you're able and hear from all of the others that want to weigh in on our behalf, but we're all better for it. I don't want to go too far without also saying thank you to my wife and boys for putting up with a distracted and absent husband and father for the last little while, going through this process and keeping up a busy practice as well. But I'm also grateful for the 12 other Iowans who've put their names forward for possible nomination today. I know almost all of them. I've worked with many in the AG's office and elsewhere in state government throughout my service. And you have many solid nominees in front of you, as I know you've seen already today as we're nearing the end of this process. As someone who cares deeply about the courts and a tail-end member of Generation X, I was especially excited, too, to see that a majority of the applicants are millennials, and I think for the first time ever. And that really bodes well for the future of our judiciary and this process that so many of the next generation of lawyers and trial judges are interested in serving on the appellate courts. And then finally, I'm thankful for the state of Iowa, because the state and its leaders have given me so many amazing opportunities, starting with my public education in the Clear Lake schools and at the University of Iowa College of Law, and continuing with this most recent chances to serve, for our Republican governor and our Democratic Attorney General. This wouldn't be possible in every state, and I'm forever changed by these gifts, and that's part of why I have tried to keep giving back. I applied for the Court of Appeals for the first time 9 years ago. At that time, I had a 1-year-old and a preschooler who knew that Daddy had gone to the big building down by the Capitol with just one dome to try to be a judge. And now I've got a 4th grader and an 8th grader with whom I'm embarking on that fun parenting adventure of sitting on the passenger side of the car while he's learning to drive. But it's not just my boys that have grown and developed over the last 9 years. Although I was disappointed not to be nominated back then, with the benefit of hindsight, I truly cannot imagine missing out on the opportunities to grow and serve that I have these last 9 years. And regardless of what happens here today, my life is richer having gotten to know and learn from brilliant and caring colleagues at the Administrative Hearings Division, in the governor's office, throughout state government, and now in the Attorney General's office. It's also, though, been a tremendous preparation for me, probably worth more than I could ever pay back if I'm realistic, to serve on the Court of Appeals. As an administrative law judge, I learned how to be a judge. I developed and strengthened my commitment to the rule of law and to procedural fairness to help make sure parties appearing before me were heard and understood and respected. And I honed my writing approach in opinions, cranking them out as quickly as I could. And then for 4 years, I had a chance to be involved in some of the most significant legal issues facing our state at a pretty challenging and consequential time. First, behind the scenes in the governor's office, and then in the courtroom in the Attorney General's office. And through this experience, I've also continued to develop and strengthen my writing abilities and my understanding of the law as I practiced at every level of the state and federal courts. I mean, as an example, I represented 8 attorney generals from around the country from both parties writing an amicus brief before the United States Supreme Court, tried a jury trial in Polk County. I've defended our state statutes from challenges across the ideological perspective. I mean, in fact, with my friend who was just speaking to you before me, we're defending the gender balance requirement of this commission from an equal protection challenge in federal court right now. 4 members of this commission were served and were serving 9 years ago when I first applied. And so they've had the chance to see how I've grown and developed, as I know, some of the rest of you have known me outside of the commission have as well. And I believe that I am now more prepared than I've ever been to serve on the Court of Appeals. Some things haven't changed, though. As I've said every time in the application process before this commission, I love Iowa, I love the law, and that's why I want to serve as a judge. I'll be steadfastly committed to the rule of law, deciding appeals based on the facts and the law, regardless of whether the result makes me happy or you happy or anybody else happy. I'll be write clear and concise opinions so that the public and the parties understand, especially why they've lost, but also why they've won. I'll be respectful and humble in my opinions and at oral argument to everyone involved. And I'll do all this to the best of my ability with a work ethic born more than 25 years ago, delivering newspapers and carrying out groceries, and strengthened still as I try to give the taxpayers their money's worth every day and many nights now. This isn't a particularly innovative approach to judging. I basically paraphrased the judicial oath, but if I have the opportunity, the honor to be able to take that oath in this room someday, you have my word that I will strive every minute with every fiber of my being to fulfill that oath to the benefit of all Iowans. So thank you for your consideration, and I look forward to our conversation.
Thank you. We'll start our questioning with Commissioner Hoytink.
As I've reviewed your application and have known of your career, Mr. Langholz, you have a remarkable breadth of experience. So you've spent time with the prosecutor's office, worked in the public defender's office, worked in an administrative capacity, worked, I'm going to say, in-house for the chief executive of our state, and now are working as advising our attorney general. That obviously lays across a very broad spectrum of perspectives. How do you think that would inform you and make you a good contributing member of the Iowa Court of Appeals?
Well, another way of saying that is that I haven't been able to keep a job very long, but I do think that it's a great background because the Court of Appeals is a generalist court. No judge is an expert on everything, or perhaps even really anything. You have as a practice, you come in with the practice experience that you've had, but even that starts to get a little bit dated as you are, serving on the bench. And I think it's a general familiarity, a perspective that's useful to draw from, to have a place to try to get started quickly researching. I think it's really important, no matter whether it's an area that you feel like you have a lot of experience in, or one that you don't, that you kind of start from square one. Again, that doesn't mean taking a long time to do it, but not assuming that you know anything. That sometimes that's one of the biggest dangers. In my experience, judges that, and I find it myself even kind of jumping into a new appeal. If I don't forcefully kind of keep an open mind. And start from square one. I sometimes assume I know what this case is about, and that it's an issue that I am familiar with, and steer towards that. So, so I would still, even in those areas that I am most comfortable with, dig in as the judges have to do in every single case to get familiar with the specific law and the specific facts in that case.
Thank you.
Commissioner Chase.
Thank you. Thank you for your application. Because you are from Polk County, and you and I talked a little bit about geographic diversity on the court, tell me whether you think that's important, and if so, how you could bring that to the court.
Well, I don't think we'd want to have all our judges from Polk County, though interestingly, as I dug in kind of preparing for this, I discovered that originally the statute did require that. It required that everybody have their office and work here, and they wouldn't pay expenses, and there was sort of a passive-aggressive, resistance effort by judges who got appointed from outside to say, we're not moving, and we're going to, sleep on cots, and eventually the statute got changed. So I don't think, I think that's wise. I don't think we want everybody from Polk County. At some level, it shouldn't matter, because at least for the results in the cases, because I think we should all be deciding the cases based on the facts and the law, and our individual perspectives and backgrounds shouldn't affect that. But I think it's healthy. There's a pretty good mix of folks from around the state currently. I mean, this position is Judge May's position, who is a Polk County person. He lives a couple miles from me, in Polk City. So it's not going to change, the geographic makeup of the court in any way. If you were to, if someone from Polk County were ultimately nominated and able to be appointed. And I think there's some benefits too, although the court works pretty well remotely, and I've enjoyed kind of learning how everybody functions. As I've met with all the Court of Appeals judges, I think there's some benefit to some core number of people being here in this building as well, and that helps the culture of the court. And I don't think perhaps that it would be healthy if there was only one lonely person here who officed in the judicial branch building too.
Thank you.
Commissioner Pearson,
No question.
Commissioner Pickla,
No questions, thanks.
Commissioner Gray.
Yes, Mr. Langholz, I was one of those commissioners on the commission 9 years ago. And I don't know if I actually used these words, but it would have been something I might have said and would be very smart, but not yet wise. So tell me, sir, what wisdom have you gained in the last 9 years?
Oh, hey, I think I could take up the rest of our time here, and that's not to suggest that I'm very wise, but I have learned so much. I think one of the most important things that was really eye-opening to me, and this comes from being an administrative law judge, was a firm commitment that the most important judicial officer is the trial judge. And I think the hardest job, that's continued to be clear to me, over the last 2 years practicing, as I often dump, very complicated constitutional, motions to dismiss on a trial judge, thinking about how that's going to be their evening and weekend project probably now for the next while. But in an ideal world, the trial judge is going to decide everything correctly, going to provide, if it's a jury trial, going to provide a fair, fair jury right, and we on the appellate side are just going to be an afterthought, making sure that everything was done correctly. And I think like most sort of law students, originally I kind of had a, you have a sort of a Supreme Court, even U.S. Supreme Court, sort of, that's the most important, thing, and that's definitely a perspective that I've gained, and related to that, the importance, although I did just talk about deciding it correctly, I think that's important, but that's maybe not the most important part of a trial judge either. It's making sure, regardless of the result, that it was a fair process, that the litigants, especially the person who lost, felt that they were heard, that they got a fair process, and time again in administrative hearings, I saw the benefits of that ultimately, then, kind of as a final resolution, even though I was just saying, yes, you don't get your, you don't get your benefits. Yes, you are going to have, a, child abuse, registry entry against you, but that people then didn't appeal any further because they felt they were heard and understood, why this, the decision came out the way it did.
Thank you.
Commissioner Hanson,
No questions.
Commissioner Bevel.
I was here 9 years ago, too. When I look at your resume on your application, and I see private practice for a couple of years, and then the public defender's office for a couple of years, and then the governor's office for 4 years, and now the Attorney General's office as an assistant solicitor. And now we're applying for the Court of Appeals, where very important work, but there are certain parameters that are set on what you can do. I mean, you got your job, it's defined. How are you going to make the adjustment from going policy to / administrative to being a judge?
Well, I've done it once already. I mean, and I made a choice after the application process, 9 years ago, that this was, a direction where I felt my talents and my natural sort of inclinations, best fit. And so, the state public defender role was very much, although I did some, there was a legal practice component to it, and I did appeals, and argued 3 times before the Court of Appeals back then, to largely a policy and administrator role. And I moved to, was an administrative law judge for 4 years. I left those things behind. There's still an administrative component to being the chief, administrative law judge, I guessed as well, but certainly, politics I left behind completely, and resigned from my sort of political activities as I felt was necessary and appropriate for that. I loved it, and I am confident that it was a good fit for me. Was not particularly interested in leaving that position other than to move into the judiciary, but and I would be honored to have the opportunity to get back to where I feel like is the best fit for me. And these last, again, the last 2 years especially, but even in the governor's office, was very much focused on law and preparing for thinking about things from a legal perspective rather than a policy one too.
Commissioner Hoyt,
No questions.
Commissioner Henderson,
No questions, thank you.
Commissioner Stanger.
Thank you. Good afternoon.
Good afternoon.
Thank you again for your application. It's great to have such a diverse group in front of us. Younger, right, as you identified as well. One of the things that comes with, though, is a concern of wisdom and potential lack of experience. And one of my observations, if I may, is of your 16 bench trials, 14 of them occurred during law school, and of your 2 jury trials, one of them was in law school. So when I look at your career development and experience, depth as opposed to breadth, with which Mr. Hoytink identified, I have some reservations that there's 1 jury trial and 2 bench trials. Now for the question. That's my observation, right? The question is, on the Court of Review, how do you think you can bring decision-making to bear when you haven't been, so to speak, next to a client or coaching them through the jury or the bench trial or district court trial experience?
Well, I have been next to a client repeatedly over the last 4 years. My jury trial involved an individual defendant that ultimately was voluntarily dismissed midway through the trial, but he sat next to me that whole time. It was, as those who have represented, individuals or individuals involved in organizations, whether you're the governor or a department head or a relatively junior employee, it's not fun to get sued. It's not fun regardless of whether it gets all the way to a jury trial or nothing happens but the splash in the paper of a petition, and we're explaining what that happened, what that means. I've advised folks in all those capacities over the last 4 years. It's one of the things, I gave a CLE presentation last year to the Attorney General's office talking about how we do have clients. And it's one of the things I try to work really hard on as a lawyer over the last 2 years in the Attorney General's office to remain focused on that and think about things. And sometimes, that's something little, like not just, dropping a big fact that, you've been added to a lawsuit, by an email, and calling and explaining things, and trying to think from the client perspective about what this means. I'm also very mindful of that about, reading an appellate judicial decision through a client's eyes. And sometimes it's not so much the result, it's the other stray comments that are included in there, and how you have to be, very careful in all of that. Every once in a while, I try to follow the appellate dockets very closely in my role currently, and every once in a while I'll spot a rehearing motion at both the Supreme Court and the Court of Appeals, that's filed because, you said this sentence here that, had absolutely no effect on the result. We're not asking you to change anything, but this could be a real problem for us because it's not true. And trying to avoid that sort of thing, at all costs, and being mindful. That's another thing, from a public defender perspective. Again, I didn't represent the indigent defendants, but I was actively involved in problem solving and hearing issues and concerns and perspectives as I tried to learn as much as I could to do job effectively. And I understand from a criminal defendant perspective as well, how those things that come out in opinions can have a significant effect on a client, and I'd be mindful and careful in writing decisions to keep all of that in mind.
Thanks so much.
Our time is up, so we thank you for your application and look forward to deliberating it later this afternoon.
Thank you.
Thank you.
Thank you.
Thank you.